Force majeure, severability, integration. Three clauses that I have in almost all my contracts, unless stated otherwise by my client that they didn't need it. Force majeure. Force majeure means First majeure is a clause that you put in a contract if you want to be discharged of the obligations within that contract. So a lot of times you'll hear an act of God or something like that. It's very similar. So you can be released from your obligations under the contract if you have something like a fire or a flood or a strike or a pandemic. If you write pandemic in your contract, you may be able to be excused from your contract if your force majeure clause mentions that a pandemic is a reason that you should be excused. Other things like war, act of God, this is like you can't do what you need to do because a pandemic is here. How can I get out of my contract? When the pandemic first hit, a lot of people are trying to figure out, how can I get out of my obligations of my contract? Do I still have to pay? How do I get out? The first thing that every other attorney looked at, and every attorney looked at, was that force majeure clause in the contract and figured out if a pandemic was mentioned in there. Because if you're trying to get out of your contract and it says pandemic, then that's your way of getting out of the contract and not paying. But if it doesn't say that, or you don't have a force majeure, how are you going to get out of the contract? So it was a lot of contract review that happened right at the point of when the pandemic started. So, I'll tell you this: a lot of my contracts I had written had epidemics, but they didn't have pandemics in them. So now, guess what? Every contract I write moving forward is going to have epidemic and pandemic, because it's just, the wording. Words have meaning. It
Yes.
means a lot, and that one word in a contract could have saved a lot of businesses that weren't able to make their payments or get out of their contractual obligations. So
Right.
again, a force majeure clause is a clause that enables you to be discharged of your obligations under the contract. Very important. Severability, again, this is a boilerplate language in a contract that basically says that if one of the sections is unlawful or illegal or deemed to be unenforceable, that it doesn't affect the validity of the other parts. Meaning that if I find that my force majeure clause somehow is unenforceable, that doesn't mean the whole contract is unenforceable. It just means that that part is going to be stricken out by the court, and that's it. So
Oh.
severability is very important. In integration clause, sometimes you'll see it in contracts and it says entire agreement. Basically says that whatever's written in this contract is what the parties have agreed to, and it is the only thing to be looked at if the party, when we get to the point of a dispute. The only thing to be looked at is what's in the four corners of that actual contract. Now, why does this become important? Why? Think about it. To that entire point that you've been negotiating along, and you're talking to the other party, you're going back and forth, you're saying things, you're trying to figure it out before you get to an attorney or before you put it on paper. Whatever goes on that paper and that contract is what governs and what should govern. So if I say, you're breaching the contract because you didn't pay me or pay my client in 10 days, like the contract said, and the person says, well, no, 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 we talked about a lot of different days. We talked about 20 days, 30 days, 2 months. What's in the contract is what governs. And you want to make sure that the other party isn't using any of those negotiation tactics or anything that they've said before or after to be able to get out of their obligations. So the integration clause basically says that this is the entire agreement of the parties. This is what we've agreed to. This is the only thing that we're going to use, and this is it. And once you sign the agreement saying that this is what you're going to look at, this is why it's so important to review your agreements before you sign them. You have to make sure that you are obligated, you're legally bound to what you're signing. So everything that you've negotiated before that didn't make it into the contract, it doesn't make it into the contract. And I don't want the other party to now bring that up saying we did all these different things and we said all these different things, and no, 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 that wasn't it. Well, if that wasn't it, then you should have said it before you signed the contract. So
Mm.
integration clause becomes really, really important because you don't want to use any of the prior negotiations or the ones after as well. Whatever's in that contract is it. That's it.
That's what we're
End of
going by.
story. The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.